As a reminder, please turn off or silence your cell phones. Good morning. You are attending the Animal Matters Commission hearings for December the 4th, 2023. The Animal Matters Commission was established and is conducted in accordance with Article 12 of the Anne Arundel County Code. These are administrative hearings, and by nature, they are informal, which means you are not hampered by rules of evidence. However, please be aware that you are still testifying under oath. Each party will have their opportunity to state their case. After each party states their case, they will have an opportunity to ask questions of the other party. Please do not interrupt the other party. You will be given ample time to talk. In many cases, we are aware that there is a history. You may briefly tell the commission about the history. However, please focus on the issue at hand. After each case, the commission will have open deliberations. During these deliberations, the public may not participate. If the commissioners have an additional question, you may answer that question. No further information will be heard, and a decision will be rendered. This decision is a recommendation to the chief of police or their representative. The recommendation of the commission will be taken into consideration, and a final decision will be made by the chief of police or their designated representative. If, as the defendant in the case, you are unhappy with the decision of the commission, you may appeal. For citation cases, appeals are made through the District Court of Maryland. For administrative orders, such as potentially dangerous, and vicious orders, appeals are made through the County Board of Appeals. Robin, you may call the first case.
Okay, the first case is going to be Andrea Mead versus Nathan Hepworth. And for practice purposes, what I'm going to say is that anyone that has an interest in this case, please use the raise hand function so that I can promote you to panelist. And for teaching purposes, I'm just going to show her then that we promote to panelist. It will kick you guys out and have you rejoin as panelists. All right, and let's make sure we've got that. Okay, I'm gonna give Mead a moment. I'm gonna get everybody on video and sound. There we go. Okay. So what I'm going to ask is that all witnesses and parties, please raise your right hand and keep your hand raised. Do you declare and affirm under penalties of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
You could answer audibly, please, Mr. Hepworth.
Yes.
Thank you. And then Ms. Mead, we're going to start with you. If you could please state your name and address for the record.
Sure. Andrea Mead, 2827 Fennel Road, Edgewater, 21037.
Okay. Mr. Hepworth, you could do the same.
155 Cardamom Drive, Edgewater.
Okay. I just want to remind everyone, like the chairman did, please utilize the mute function if and when you are the party that is not speaking. And I am going to step out and turn things over to you, Ed.
Okay. All right. Ms. Mead, as the complainant in the case, please state your case.
Sure. So I live in Gingerville Woods. Mr. Hepworth lives in Gingerville. We're sister neighborhoods. The morning that I went out and took the photo, I was actually with my daughter. And she has an animal care business, so she walks dogs in both neighborhoods. I was helping her that morning because she had a busy schedule. So when I went out and we went over to Gingerville, I saw Mr. Hepworth with the dog off leash, and I submitted an affidavit.
Okay. Robin, just for Principals, can we bring that picture up for everybody to see?
Absolutely. I'm going to switch to share screen. You select which screen it is that you want to show and click share. If you want, I can download this and try and turn it, but here's the picture that was submitted. Not the most tech savvy, but I can try to. Is everybody seeing the affidavit? I just want to make sure we're on the right thing.
Yeah, I have the affidavit pulled up here. Is there do we have access to the previous affidavit as mentioned? And was there a citation with that previous affidavit?
This one I have is for 7/17. This case file that I have is just for this one, but hang tight with me. Is everybody done seeing the picture?
Yeah.
Okay, I'm gonna stop sharing and I will see what I can find for you.
Hey, Dr. Hemmer, was your question answered?
No, I think Robin's actively trying to look into that now.
Okay. While we're waiting on that, Miss Mead, do you have anything else?
Sure. I mean, he did have a previous affidavit submitted. I am a notary and I notarized that affidavit. I think it was last year for one of my neighbors here in the community. They had asked him to put the dog on a leash in our rec area. He did put it on the leash at that time. And as soon as he got at the end of the path, he let the dog off leash onto Fennel Road, and that's why she submitted the affidavit.
Okay.
But there was no citation associated with that affidavit. Is that a correct understanding?
There was a citation, and it was found guilty. So that one has already been marked as guilty, and I'm just checking my system, which is having a case of the Monday mornings. To clarify if that was paid or not, but our system does indicate that it was marked as guilty.
Okay. For the same offense, running at large.
Animal at large, for a boxer named Rufus.
Very good. Thank you, Robin.
You're welcome.
Okay, Miss Mead, are you closed for the time being?
Yes.
Okay. Mr. Hepworth, you have the opportunity to speak now.
Thank you. Good morning. And thank you for the opportunity to address. And I wonder if the photo could be reshared. If not, I would say that the violation indicated, which is 12 section 4-905, animals running at large. Thank you. Yeah, you can blow that up if able, that would be great. But my understanding and looking at the website here of Anne Arundel County's laws, at large means three things. There's three criteria to be able to meet the at-large law. The first is that the animal the animal is off the property, that it is not leashed, and it is not under the control of a responsible person. I would say that it doesn't meet at least one, perhaps two specifications of the law. First, under control. The dog looks like it's pretty much under control, running right alongside of me. I would note the time that this violation occurred at 6:16 a.m. So at 6:16 a.m., we are going up for a run in the neighborhood. Dog looks like he's under control of a responsible person to me. You may also notice if you zoom in, there is a leash that's a lanyard that goes around my torso there. That's this leash. It's a running leash, so it wraps around my waist. Then I pull it around my torso again and put it over there. When we do see or encounter another animal or something that would require it, I do then attach him to a physical lanyard. However, he is always under the control, and it's sorry for the blurry. I can unblur my screen if you'd like. He is always under the control when we go running of an electronic lanyard. This is a sporting dog electronic leash. So same principles apply for those who have their property, what do they call it, invisible fences. Here's the remote control. Here's the device that goes around his neck. And he's always under the control, my control, with that device. And so I would say he's under control here, and he is on both a electronic leash, and when necessary, I do apply that lanyard. You can see it's around my torso, the black line going through my shirt.
Okay. Has Rufus undergone any other training? Mr. Hepworth, has he received any obedience training or anything along those lines?
Well, I would say yes, I have trained him, but if you're looking for a more formalized certification course, I couldn't produce those documents. But we do have Rufus's veterinarian on the line, and so perhaps he could testify. But I think he's very well behaved. He responds both to voice control, and that can be demonstrated if need be. But I've trained him.
Okay. All right. Any questions from the commission?
I guess as I'm reading the at-large definition in Title 4, 12.4, 101 definitions, it says at-large means off the property, not leashed, and under the control of a responsible person. So based on what you've just said, you have to go up from there. You've got to go to the definitions, 12.4, 101 definitions. And I believe all those criteria are met in this case. So I just want to understand your interpretation of the definition, because I think you're bringing up a legitimate point. I just want to make sure that we're understanding the definition of at-large correctly.
We've encountered this before. The second "and" in that sentence to me is what's critical. It's not an "or." I would agree with Mr. Hepworth if it said not leashed or under the control of a responsible person. And to me, I think that makes the difference. I mean, once you get to the not leashed, the animals at large. However, and I know this has come up before, and it's not addressed in the statute anywhere. The statute doesn't specify physical versus electronic leash, and I find that problematic. Even though I think we've all kind of assumed, it has to be a physical leash. It doesn't say it, and I'm not quite sure, I guess, what to do with that piece of it.
Office of Law is on the line if you all do need a legal reference.
Well, as Jennifer or the Office of Law, I'm reading this as if the animal's off the property and not on a leash, yet under the control of a responsible person, the animal's still at large. Is that a
Yes, I agree.
reasonable interpretation of that? So that technically this animal is by definition at large. Is
Well, that depends on, because I guess, and I would agree with you, except that I don't see anything in the statute that insists it be a physical leash. I'm not even sure if
Leash.
we recognize electronic leashes.
so really the issue is, what does leashed mean in the code? Is that where we're at?
That's my question, yes.
Good question. I see your point. Okay. Thank you for clearing that up, Jennifer. I appreciate
If
that.
we're discussion, I mean, you know, I use an electronic collar on my dog as well, and I wouldn't consider it a leash. I mean, a leash to me is a physical restraint. You know, electronic collar is a device that you can control an animal with. It's not a leash, in my opinion. I mean, I understand that opinions can be different, but that's what how I see it.
Okay.
Just for the members, and Jennifer's a lawyer, and I know Office of Law is on here. But my understanding is that when something isn't defined in the code, then you go with the standard accepted definition. So what I did was I Googled leash definition, and here is what I come up with.
Yeah, that's what I did too, Robin, and that's what I came up with as well. The definition is a physical, is something physical.
Okay, would Curran like to chime in at this time, or do we need to take a break and do that? Robin?
I mean, I could join in right now because there's nothing really that the Office of Law has here. It's not defined in the county code, so it really reverts to either the agency's interpretation of the section or the common definition of leash, neither of which would be a legal analysis by my office.
Thank you. So, go ahead, Mr. Hepworth.
I don't see a raised hand under, I'm not looking to do that, so that's why I had to do a physical hand.
That's okay.
But I guess I would, again, point out that underneath the statute, there are three parts to that. And the word "and" is used twice. The first time it would say an at-large means off the property and not leashed. So when we look at those, it needs to meet both those specifications. And then the third "and," or the second "and" in the third specification is "and" under the control of a responsible person. If he's is he under control or not under control? Because if the at-large simply means not with a tethered physical leash, then the statute would just end with the first "and" they only have the two specifications, off property and not on a physical leash. But I would say that it's included that there's an additional word "and" conjunction and under the control of a responsible person. So is he under control?
Well, I think that would be true. I mean, I'm not trying to debate. I mean, there's a possibility that a dog can be on a leash and out of control at the same time as well.
Yes,
That's why.
agreed.
Okay, Mr. Hepworth, just a question that I have. If there is no physical leash and somebody is visually seeing you jogging with the dog and there's no physical leash, the electronic leash, exactly how does that keep Rufus from running away and going after an individual or another dog?
Yeah, thank you. I think it's under the same principle. You think about all the dogs in this neighborhood that are on invisible fences, and we trust them. And I mean, I can speak about just the two that are across my property on the opposing side. When cars go by, the dogs are chasing those vehicles, but they stay right across the line, because when they get close to the line, their collar vibrates. And there's no difference. And this has three functions. It has both an audio tone, which tells Rufus to sit. If I was to push it, he would sit. It also has a vibrating. That's usually what I would use first to get his attention. If I don't have his attention, he continues to ignore that second. Then it does have what's called static, electroshock static. It does deliver with the two prongs. It delivers a shock that gets his attention. So that's actually the third or even fourth line, I'd say, of defense. He responds to my voice. There's fox in this neighborhood, there's deer in this neighborhood, raccoons and squirrels, and you name it, and even other dogs. He will respond and come on my call. If that was to fail, then the shock would be delivered, the static.
And do you have to like press a remote when that happens, or is there a set range? Or
that's right. So it's here. Let me just unblur my screen. So I run with this. There's the three buttons, buttons on the side there, but I deliver, and I put it around my neck. And this is handy, or I have it in my hand when I'm running.
okay, thank you. Do we have any further questions from the commission, or any more comments from the complainant or the defendant?
Sure. I mean, I believe, I see that he has the electronic collar. There have been people in the neighborhood that have electric fences, and their dog has breached that fence. I've notarized many affidavit for dogs getting out off of a physical leash. And we're not dogs, so we don't know what our dog is actually going to do if it felt threatened or if it was trying to protect their owner. So that's why, I'm all about safety. We have a lot of children running, we have people on bikes. We really don't know what our dog is going to do. And, bottom line is, I'm just an advocate for a leash. Yes, you have your electronic collar, but, to me, it doesn't mean that if the dog felt threatened, it wouldn't attack. So, so anyway, that's why I submitted it.
Okay, thank you.
Sure.
Okay, commission is satisfied. Complainant and defendant both satisfied with the presentation of your cases? If so, we will close for deliberation at this time. I don't see anybody else with any questions, so I believe we will take this opportunity to close for deliberations, and if there are any further questions, we'll call upon you. Thank you for your testimony.
Thank you.
All right. We'll start with Nicole. Go ahead, Nicole. How do you feel?
So I think that I kind of echo what everybody said. There's no specific must be a physical leash. Without that determination, I really could go either way, because I mean, although it's an electronic collar in my mind, not a leash, but I think this is in this new age of technology. I think that we're going to see this more, and we should probably decide and make a precedent about what, running at large leash means. Additionally, I also see that continuing to use the electronic collar could also invite more affidavits in the future, and it could be in his best interest to put the dog on a physical leash just to prevent this in the future. But right now, I'm on the fence.
Thank you, Nicole. Jennifer?
Oh, sorry, it's having a little trouble unmuting. Nicole is right. I mean, I think it's a clear case of the, of our laws not keeping up with technology. And I mean, we see it a lot. I guess I feel for Mr. Hepworth, because the average person reading that statute, he might have thought he was in compliance. However, he's had a prior at-large citation. So I think in this particular case, he was well aware of what the criteria was. But anyone else reading that could think that their electronic leash satisfies that requirement. I agree that I guess we need to set a precedent or at least make a determination for how we're going to do it moving forward until the law catches up. I would be inclined, though, to err on the side of caution and make our determination be it should be a physical leash, only because if for no other reason than, I don't know about the rest of you, but I had a very difficult time seeing in that photo whether or not there was the right kind of collar that could have matched up to a remote somewhere. It's so much easier. You can either see a physical leash or you can't. I think it's too subjective to me, especially if we're going to use pictures as evidence, and we're getting ready to discuss the statute where they're talking about authenticated digital evidence. Even in a video, I'm not sure that I could have determined whether or not that dog had on an electric collar. So I'd be inclined to say the animal was running at large and that leash should be a physical leash.
Thank you, Jennifer. Corporal Wall?
Can you guys hear me?
Yes.
Yes.
Okay, all right, I'm having problems with my computer. I interpret a leash as a leash. I should be able to see it. I'm with Jennifer on this one. Our canines all have e-collars, but they also have their lead. Those dogs can push right through an e-collar. And I'm doing lots of Google searching, trying to figure out what this magical electronic leash is, but everything comes up with the same kind of e-collar technology that we use, and it's a training device. And I mean, yes, the dog responds to it, but as we all know, they can run right through that electrical stimulus. So in my mind, I think that a leash is a leash. Your hands on it, it's attached to the dog. And, I'm going over this over and over again, reading at large, he's off property. He doesn't have any sort of physical attachment to the dog. And it says under the control of a responsible person. So I don't know that he said the dog doesn't have any sort of training besides what he taught him. So in my mind, it's at large with all those factors.
Thank you. Dr. Hammer?
I'm pretty much in agreement with Jennifer and Corporal Wall about this. I give Mr. Hepworth credit of, bringing the at-large definition once again to the forefront for our discussion. But I think we have to heed what advice we got from the Office of Law, which is that if there's no definition in the code, we got to go by the common definition. And common definition is a leash is a physical attachment from the human to the pet. And based on that, I believe that fits the criteria at large. And I think this animal was at large, and I'm opting to uphold.
Thank you. Tom?
Yeah, I pretty much agree with the last 2, 3. I mean, pretty much with everybody. I mean, I've used an e-collar with my dogs. I've had 2 pointers, an English pointer and a German short-hair pointer. And, it takes time to recognize that your dog has changed his activity. Like you could have a dog that's responding at a low level. My controller goes from 0 to 127. And I can operate, the animal, keep my dog, under control at a level 13 until he sees a squirrel. And then all of a sudden he has to be controlled at a level 30. or potentially worse than that. And it takes time physically to make that change and to identify that that's going to happen. And we all know, we've seen how quickly these things can escalate and how fast you can turn a corner, a blind corner. There's a dog, there's a kid, the dog reacts. You don't have that time to press a button to even think about it. So I think for that reason, for Jennifer's reasoning of being able to see a leash, until that statute changes specifically, or there's some, I think that I'm fully on board with upholding this as running at large. I think it's how we've done it for years, and I understand that there's new technology, but I would definitely not refer to it as a leash. So I would uphold the at large.
Thank you, Tom. Yeah, I'm kind of in agreement with just about everybody. The law we're constrained by says what it says, and until it's changed, I believe the intent of that law means a physical leash. It would be better. I do understand the freedom of jogging with your dog, and I applaud that. That's great. However, for the time I believe it would take to react with the remote, as opposed to the instant leash having a parameter, would be best for everyone. So that's my take on it. I think we're all kind of on the same page here. So the next thing would be for a motion. If anyone can come up.
I move to uphold the citation for running at large.
Okay. Is there a second?
I'll second it.
Okay. All in favor? Okay, that's that. Now, before we get into the legislation at hand, has everybody had the opportunity to review the November 6 minutes?
Yes, I have.
Yes.
Okay, want to make sure that they look good. I think the last time was a slight error that needed to be. Tom, you brought that to our attention, and thank you. That was corrected and signed off on. So, unless anybody sees an error in the standings of the minutes, probably need a motion to accept the minutes as read or as noted here.
I make a motion, we accept the previous month's minutes as noted in the record.
Okay. We have a second.
In a second.
Okay, seconded by Jennifer. All in favor? All right. We will now move on to the legislation, I suppose, portion of this meeting that you were notified about. First, does anybody need to take a break first? Because this could probably get a little lengthy. If anybody needs to take a bathroom break, coffee break, water gets.
I'll go over that real quick. That's all right.
Let's go for 10 minutes. We'll resume at, let's say 9:45. Is that okay?
Very good, thank you.
Okay. Okay, once Dr. Hemmer gets on board, we'll begin. I'll give him another minute or so. There he is. Okey doke. We will resume, and this part of the meeting today concerns the introduction of the legislation, and I will defer to Robin to bring us all up to speed on what this is about and how it could potentially affect the commission going forward. Robin?
Okay, so everyone has a copy of the legislation that was sent to you all. I recognize that we have some new commission members, therefore that were not here when we had similar legislation suggested back in 2022, which is why I included that in the drive for you all to review if you had interest. Including the notes. There are a lot of similarities to that. However, there are some differences. I'm here mainly, and we have some reps from Office of Law here as well, to try to point out what the differences are and answer questions, not give my opinion on how you all should proceed with your recommendations to the county executive, who has reached out for your input, and he's also reached out for the Animal Welfare Council's input on these drafts. So just going through the legislation that you were sent.
Hey, Robin.
Yep.
Robin, what prompted all this? What's the motivation behind all this? I know we had this back a couple of years ago. Is this just that fire still kindled and going?
Yes, this is still a reaction. My understanding is that this is still a reaction to the Lucy and Odin case.
Okay, that's what I thought. Thank you.
You're welcome. So the first recommended change is in the definition of domesticated animal. What this potential change does in my mind, and again, I have two representatives from the Office of Laws here, but my understanding is that this would remove if a animal was involved in a public safety case, such as being at large, and the victim animal involved was a typically caged animal, such as a bird, an African gray, a guinea pig, a rabbit, a reptile, or a fish, that would not be considered a violation of the public safety laws. And just to give an example of something that we have had happen in the past, we have had times where an at-large animal has broken through a screened porch and has caused harm to an animal inside. So if that animal inside that was injured by the at-large animal that went through a screen door to get into the home was such a thing as a gerbil, a hamster, an African gray, one of those things that may be a family pet for some, but may be considered trying to choose my words carefully here, not as much of a member of the family pet to some others that maybe aren't owners of such animals, then that would not be considered a public safety violation.
In the example you just gave, of this happening, are you talking about like the neighbor's dog coming onto my screen porch, busting through my door into my gerbil?
Yes. Because this is changing the definition of what animals would be included. So yes, if my dog got loose, broke into your house and killed your gerbil, I could do at large, right? I could do property damage, I could do those things, but I would not be able to you would not be able to consider my animal dangerous for having killed your animal.
Gotcha. Okay.
But this may sound really stupid, but what if my gerbil broke out of my house and ran over to your house and bit your cat? Would that animal then could not be considered in this statute because it's not considered a domesticated animal?
This only excludes them from subtitle 4.
Okay, that's
So
right.
only, yeah. But I mean, I
Okay.
guess, yes, in theory, based on your example, I guess it would mean that we couldn't call your gerbil dangerous for biting my cat.
Well, I'd be more concerned with like a snake or something like that someone was carrying around with them outside of their home. So that happens, I think, a fair bit.
Or a bird. The
Or a
big
bird too,
birds.
same
Right,
thing.
that
Yeah.
Yeah,
takes
the
your
big
finger off.
birds. Yeah.
To
Yeah.
clarify, in subtitle 4, public safety threat, an animal may not pose a threat to public safety, and the agency may designate an animal as potentially dangerous, or vicious. So that doesn't use domesticated animal for
Okay.
what animal care and control would have the authority to designate or what can be a
Okay.
public safety threat.
Okay.
So if a snake or a rampaging gerbil gets loose, they would be able to still impose public safety threat conditions and restrictions on that animal.
Thank you, Karen. I
Yeah, thank
had
you.
not thought about that perspective of it, only it being a victim. So thank you for that clarification. I don't know how the commission wants to do this. If you want to take on each one of these, do a motion and take a vote as I go, or if you want to go through all of it and then do it as a whole. In previous years, when there have been lots of changes, what we've done is taken it piece by piece because it can be overwhelming for someone to try and make a motion or as a whole.
I think doing a page turner and doing it piece by piece just breaks it down compartmentally. That's, I think, easier for everybody and us to attack. And then go from there. That would be my suggestion to the board.
Yeah,
the
I think
commission.
that would work. I think that would work better. As Robin just pointed this out, yeah, that that kind of went past me as I was reading this. But yeah, my mind went to the prohibitions in the county as to what you can and cannot have as pets. And you can't have raccoons as a pet or a possum and stuff. So I just kind of said, okay. But now I see, and of course, the fish is not going to jump out of its aquarium and go to anybody else's house. But an iguana could. An iguana very well could get out of my house and go to a neighbor's house and eat their mice.
But as Karen said, that we could then take action on. It's only if your iguana was the victim.
Right. Or, as somebody stated, a alligator as a comfort pet or whatever you call them. But yeah, I agree. Saying that, I agree we should go, as Robin points out, the flaws as we go through this, and then just do it like we do at the end of our at the end of our hearings, and go person to person. I think that would probably work better. So Robin, since you're leading it, why don't you, I guess you'll go person to person and say how they feel? Or do we want to just raise our hands and say this should be upheld or rejected or whatever?
I think it would be great to have a motion from someone.
Can I ask a question real quick? And I apologize if this is a stupid question, but this just popped into my head. Because this specifies an animal that's typically kept in an indoor cage, so if the animal could be both, would it not apply? And what popped into my head was I have friends of mine that have a koi pond in their yard. And I've seen people that have kept koi in a aquarium indoors, although I get that they are more large water animals, but I guess how would you deal with an animal that could be either or in this scenario?
That might be an Office of Law question. The one that came to my head is that for some people, their rabbits in their home are free range litter trained rabbits that run the home, or for a lot of people with large birds, they may have much greater access. I'm not exactly sure where fish in a koi pond would fall, but I do want to remind everyone that with the current law, we do have some discretion. So one of the things that comes to my mind is that for some people, and I'll just use another example of something that could kind of fall into multiple categories, chickens, for example. So for some people, a chicken is livestock, right? That is their purpose. That is where they fall. But for some people, a chicken is a purse chicken. Like their chicken goes everywhere with them. That's their pet, their family member. And so the current legislation gives us, or the current code gives us, the opportunity to really assess each of those situations. And, you know, if it's typically something that is, you know, livestock outside, we can factor in a little bit differently how that pet or animal is perceived to the family and what the impact is, because it is a different impact in my experience on families. You know, if it's someone that's raising their chickens for food or using them just as egg laying, but may not have a great bond with them, versus someone that their chicken is like their baby and they dress it up for different holidays.
How does the animal doing I guess from how does an animal distinguish between a livestock chicken and a purse chicken?
The animal doesn't. Similar to how an animal doesn't distinguish between a feral cat and a squirrel, which is why when both of them are out large in nature, we wouldn't take any public safety reaction on that. But your chickens, if you own chickens, should be confined, right? They shouldn't be roaming the neighborhood. They should be on your property, not roaming freely. We should be talking about animals that are not in violation of the law at the same time.
Can I ask a little bit more broader question, Robin? So this legislation is coming to the council to take a look at. Why is this before? I understand why this is before us, but where are our recommendations going to fall? I mean, is this just a courtesy notice that the county council is going to pass this, and they're just, by letting us opine on this, just giving us a transparent, hey, heads up, this is coming down the pike? Or do we actually have some ability to fine tune this to the point that the council will take our fine tuning at heart?
My understanding, and Office of Law can correct me if I'm wrong, this has not gone to council yet. This is currently an administrative bill. And the county executive is seeking your input on whether or not you support these recommendations, would like modification to these recommendations, or what the commission's thoughts are on these. That's
okay.
my understanding.
Oh, okay. So this is still in the developmental process of the bill. Got it. Okay. Thank you, Robin.
You're welcome.
Well, I guess if it's all right with the commission, I'll make a motion that we delete the change that's in there. My concern is that if we keep the changes as proposed, it's just going to open a hornet's nest for us of interpretation. And then we're going to be stuck, just like we were with the last case, having to make precedent going forward. So I think it would be better if we kept this as nebulous as possible and as ill-defined as possible. That'll give us more latitude going forward in dealing with cases like this. So I make a motion that we recommend that the change in section 23 be deleted in its total. In total.
And I'll second that. I believe it muddies the waters, as they say, and for what we already discussed, it makes a mess out of an otherwise good intent.
Agreed.
Yeah, I mean, I see the same. I mean, like, again, like, you know, someone carrying their snake or bird around and a dog comes up and attacks or kills it just because it should, you know, would have been kept in a cage. You know, there's circumstances all across the board that could change why animals should be considered, like, you know, how it was, you know, killed or whatever. Like, it just doesn't, I don't see why we need to be so specific. So,
Do we want to take a vote?
yeah,
All in favor of the motion?
I'm in favor.
Jackie Cohen, I can't see your hand. I don't know if you're wanting to vote or not.
And I apologize for being late. But because I've been involved in the conversation, I will abstain.
Okay. And everyone else was in favor?
I believe so.
Yes.
Hey, Robin,
Yes.
for the next 3 sections, because I don't know, can we have either Jennifer, who's a very good educator, or the Office of Law explain to me the relative differences in evidence between a preponderance of the evidence, clear and convincing evidence, and beyond a reasonable doubt, so I can have a better understanding of what we're going to talk about going forward, because I really don't know the differentiation between those 3. And it looks like going the next 3 sections, we're going to have a discussion on kind of what evidence is. So if somebody could give me a basic primer or an executive summary on the difference between those 3 forms of evidence, I would be most appreciative for myself, because I don't understand it.
If you want one of them to do it, that's fine. Otherwise, I can read you the definitions that I pulled from the last time that we had these conversations.
Now let's go with the definitions we had last time. That way we're staying consistent.
Okay.
Thank you.
So clear and convincing, this would mean evidence is, oh wait, I guess I should start with preponderance. Preponderance is essentially most likely that it happened. It's the least restrictive. Based on the evidence that is there, it's most likely that it happened. Clear and convincing, just for reference, this is the same level of evidence required for misdemeanors for a person that could lead to jail time for a person. Means the evidence is highly and substantially more likely to be true than untrue. The trier of fact must have an abiding conviction that the truth of the factual contention is highly probable. And then, let me find my beyond a reasonable doubt. And so this is the level that would be required for felonies for a person. It means that there is no other reasonable explanation that can come from the evidence presented. In other words, you must be virtually certain of the facts of the situation.
Very good. That cleared things up for me tremendously. Thank you, Robin.
Absolutely.
Dr. Hemmer, when
Yes.
for my mock trial students, I give them numbers. I don't know if you find that helpful. For me, it's
Uh,
helpful.
Please.
When I'm getting my kids to do this in trial scenarios, the preponderance is just the 51%. You just got to tip the scales a little bit to get to preponderance of the evidence. Clear and convincing, we put at about 75%. That's about how sure you have to be. And the beyond a reasonable doubt is 99% or better. And I just know that for my kids, they find the percentages,
That's
that
great.
analogy.
That's perfect. Thank you very much, Jennifer. That's really what I needed.
Okay, so again, just to try and take this step by step, the next change that is suggested in the draft that you all have is changing the level of evidence required, or the burden of proof required, from preponderance of evidence to clear and convincing evidence for our section to issue a potentially dangerous order. So essentially that would move it up from we think it happened to you were 75% sure happened, using Jennifer's terminology. And so this would make it so that our current team would have to be able to prove at a higher level what it was. And I'm not giving my opinion, so that's all I'm going to say.
If I may propose something to the commission on this section, they're talking about clear and convincing for potentially dangerous, clear and convincing for dangerous, and then beyond a reasonable doubt for vicious. I would consider that we make this a sliding scale like Jennifer had prescribed, that we make potentially dangerous still at a preponderance of the evidence. We maintain that the same. Dangerous because we are making this animal more of a public safety threat. Keep that at clear and convincing. And then I'm comfortable that we're going to vicious, beyond a reasonable doubt, I think is reasonable and fair to both the animal and the owners. Looking at all three of those, not to get ahead of Robin, but that's how I would suggest that would be my recommendation going forward for those three sections. Just, as the severity of classification becomes, so does the burden of proof, much like Robin was saying. We needed, clear and convincing for a misdemeanor, and then we need beyond a reasonable doubt for a felony. So that seems like a reasonable, logical approach. That I think a framework that we can work within, and a framework that I think the public can work within as well. Those are my thoughts. Thank you.
That makes a lot of sense. And thank you, Dr. Hemmer, for that, because by the very word in it, the first one is potentially. So it's potentially. But the next step is the word potential is out. It is dangerous. And then the last step is vicious, which unfortunately could lead to the death of the animal, the putting down of the animal. So yeah, I agree with that wholeheartedly, Dr. Hemmer. That makes a lot more sense.
Yeah, I mean, I'm trying to think of any, cases that we've had. I mean, I've been at this for a lot of years, and I'm trying to think of, issues we've had with preponderance of the evidence over the years. I guess maybe I don't see the follow up and the, what's actually happening to these people that are bringing these animals in, and a lot of times we don't see them again. But again, I kind of agree with Dr. Hemmer here. I mean, I don't, especially for potentially dangerous, I do see potentially bringing a more stringent, look at a dangerous case. I can see bringing more evidence and having to do that, but for potentially dangerous, I just don't see why we would need to change that at all.
I honestly, with Jennifer's definition, if it was really 51%, and maybe this is just because maybe the commission members have not been clear, nor have I, that it's a 51% thing. I think we already use a stronger level than that on any of.
Yeah, I mean, that's kind of how I feel too, Robin. I think that's, I never would have thought of it as 51%, generally speaking. No, I mean, I think the times where it becomes an issue, when we do have he said, she said type cases is where it becomes, where it's not so perfectly clear cut, where we have to kind of make up our own minds as to like what's actually going on there. It can be, that's where it would be. But I think that if we're not, with the potentially dangerous and dangerous, I agree, Dr. Hemmer. I think that's the way to go. Just
And Jennifer helped by the 51, 75, 99. I think that follows. Very good.
I do, I guess, also feel obligated to remind that, what the case that brought this forward for everyone was the Lucy and Odin case.
Yeah.
And in that particular case, Animal Care and Control had done a vicious order. The commission had recommended moving it down to a dangerous order. And there are individuals in the community that still stand strong that there was no evidence in that case. And so just in, you know me, I always want to be transparent with you all. You all came to recommending a dangerous, and there are members of the community that still feel like there was none. So if we consider moving the burden of proof to a different level, for any of them, any and all, I just think it's important that people consider that the commission found it necessary to do a dangerous order in that particular case, and that there are those that would not find that the level of evidence that was presented there was sufficient even for a dangerous or potentially dangerous.
And that was, I mean, I remember that case, and I think most of us, or at least I know Tom was present for that case as well. But and I think, just so you know, Dr. Hemmer, that's also part of what's spurring the authenticated digital evidence. There was no eyewitness to the attack. In the case that brought this forward, in the Lucy and Odin case that Robin was talking about, it was basically just based on what we heard. More likely than not, I mean, that it just seemed like that's probably what happened. But when you're talking about, potentially putting a dog down, saying, it's probably what happened, just isn't good enough.
I think it is important to note that there was an eyewitness. They weren't able to come to commission, but we hadn't.
But they didn't actually,
from them, and we do at this point have the sworn affidavit from that individual.
And that's another difficulty for the commission, because we're not hampered by rules of evidence. But there's a lot of times in cases that I see come here that would never fly once you got to a trial court, because the evidence just, it's not there. And saying my neighbor, sister's cousin, brother told me doesn't fly anywhere else. You need the person who saw it to either come in and speak up, or, you need that digital evidence, and that always presents a problem for us. But I know Jackie's trying to talk, and I'm sorry, I see her raise her hand.
That's okay. I just because I wasn't involved with the commission at the time of apparently this case. Can you give me a little more detail about the case?
Sure. So the case was that there were two dogs that were involved in the killing of a cat that was on its property. The eyewitness that had written the email said that he was outside at the time, heard the commotion, and then went around to where the commotion was, and he saw both of the dogs pulling on parts of the cat, and the cat died. He was not able to attend either the commission or the Board of Appeals hearing. He had moved during the course of the process, and we were unable to get a hold of him to come in. And it being in an email that he had sent his statement, and that email, because he didn't have email, being written from someone else's email and signed by him, brought a lot of question for folks as to whether or not it was really his word or not. Because a domestic animal had been killed, Animal Care and Control issued a vicious order. The commission deliberated on it and recommended a dangerous order. At commission, the owners of the animal had said that they would not be able to come in compliance with a dangerous order. Therefore, the chief of police recommended that we uphold the vicious, as they wouldn't be able to come in compliance with the dangerous as they had advised at the Animal Matters Commission. That case then went to Board of Appeals, which is the next level of appeal for our orders. At Board of Appeals, the vicious orders were upheld. The owners appealed to Circuit Court. At Circuit Court, the judge remanded it back to the Board of Appeals, saying that the case had not discussed the mitigating circumstances and whether or not there had been any provocation, essentially, from the cat to cause the dogs to be involved in the attack. At that point, the administration recommended just issuing an order and the owners coming into compliance, and the owners did that, and the dogs were released after 384 days here at the shelter. That's the short version.
Thank you.
And just full disclosure, I don't know if it matters, but just to make sure there's no appearance of impropriety. The attorney that I share office space with was the attorney that took that case up to Circuit Court. So I was not involved in it in any way. And I had no, this was way after my involvement on the commission, but I just need to disclose that.
So here's another more global question, Robin. I just had this thought. Maybe we're evolving to the point that we should be our own commission separate from the police department, and maybe we should be hampered by the rules of evidence going forward. Is that something to consider as well?
Certainly making changes to how the commission is and making suggestions on that could be. I can tell you that when this was discussed previously, and we were looking for, how do we resolve this? What would be another mechanism to make sure that we don't end up back here? When I had made my suggestions back in 2022, one of the things that I said, which wouldn't actually require moving the commission, was just make it so that the commission was making a decision as opposed to a recommendation. If you all made it as opposed to a recommendation, I feel like that would be a simple change to the code. And then your downgrading of it from vicious to dangerous would have been where we were.
Yeah, I think that's probably where I'm just talking to the commission, my fellow commissioners. That's where I'm going with this, because it seems to me that every time we get these big cases like Odin and Lucy, we find ourselves in the situation where it winds up getting kicked to the Board of Appeals and the Circuit Court. And the Court of Appeals, that if we had just made a decision, it wasn't a recommendation, we would forgo all that. That would put us more in line with how the rest of the other commissions and boards work in the state. I'm not a lawyer. Just as my understanding from my civics classes.
It wouldn't stop it. Even if our decision was final and it wasn't a recommendation, they would still have just basic due process. So they'd have the opportunity to appeal it to the Board of Appeals and then to the Circuit Court. So just that piece of it wouldn't change.
But it would keep the police department out of it, the chief of police out of it, correct?
That it would.
And maybe,
yes.
And maybe that's what if I'm speaking for you, Robin, please correct me. Maybe that's where Robin and the chief of police ultimately want to go with this, that they're basically out of the loop in terms of rubber stamping our decision, and they get blindsided by something we did, and then it just blows up in their face, basically. Whereas if we just made the decision and then moved forward, the chief of police and the police department's basically out of it, and they've got really nothing to do with it. It's something that we did. Does that make sense?
One of the things that has always been difficult, I can say for myself, I don't necessarily feel comfortable speaking for the current chief or previous chiefs of police, is that ultimately animal care and control, our responsibility is public safety. So if we feel like something that you all recommend or anyone recommends is not in the interest of public safety, we tend to err on the side of safety. And for most of you who've been on the commission for a while and know that it's rare that we don't recommend upholding the orders that you all have recommended, or the changes, modifications, etc. But there have been a few rare times where that has happened.
Right, that was just a thought I had looking through this. So okay.
I'm having a thought right now about what about your recommendation, Dr. Hemmer. And I think this speaks more to, as far as the evidence goes, and I'm actually rethinking what we discussed, because the difference, I think the changes that should be made, it should be, when we talk about a potentially dangerous versus a dangerous animal, what we're requiring of the people who have to bring their animals in is exactly the same, except for a difference in the fine, if I'm not mistaken, right? Correct, Robin? I mean, essentially we can make them do the exact same thing.
Yes.
So if we're holding them to an evidentiary standard of, it's basically like, well, if we can't prove it one way, we can still make you do all the same things with less evidence. You see what I'm saying? Like, if I can make you walk your dog on a leash with a muzzle. I can make you, have secondary barriers. I can do all the things we do in a potentially dangerous order. We can do in a dangerous order, with a change in cost, essentially. So would it be right? I mean, now that I'm thinking about it, would it be correct to be able to have that at different evidentiary standards? Or would it be better to change the potentially dangerous, some of the regulations within, or some of the things we can do at that level, so that one thing stands out from the other as a mechanism? You know what I mean? Like, maybe we can, I don't know a specific example, we'd have to discuss it, but
I see your point, Tom. I see your point, and I think it's a good point. Really, I think the differentiation between potentially dangerous and dangerous really is evidentiary in nature. And I think even though for a vicious dog, even though we can put vicious dogs, we can destroy vicious dogs, but for dangerous and potentially dangerous, we have the same protective mechanisms for public safety, which is ultimately what our function here is. So having the same outcomes in terms of what the pet owner has to do for a potentially dangerous and dangerous dog is the same. And really what we're saying here, I believe, is that based on what evidence you have will dictate whether this is a potentially dangerous or dangerous dog. But how we address those dogs with fines and or other stipulations that the commission may impose, it should be basically the same, because ultimately we have to protect public safety. That's ultimately what we're tasked to do.
So I think it's important to note, and I hear you, but I think we may be confusing levels of evidence and why we do the different orders. Does that make sense?
No, I'm not, I understand it, but what I'm saying is we can basically put the same level of, responsibility on an owner one way or the other with differing levels of evidence. So like if we're hearing a case for a dangerous order and we can't come to the level of evidence that we'd say, okay, this can't be a dangerous dog because we don't have the level of evidence for that, but we can drop it back down to potentially dangerous. But then the person is being, essentially doing the same exact public safety thing we would do otherwise. We're changing the name, the name on a piece of paper. We're not really changing the outcome for that animal.
Right. Well, and the goals of the potentially dangerous and the dangerous are not to take people's animals away from them.
No, I'm
Both
not.
of those are just to put in place protections to prevent
Absolutely
whatever incident occurred from occurring again.
I guess what I'm saying is, potentially looking at it, I would say that maybe like the dangerous order, you'd have to follow every stipulation in that order. Whereas a potentially dangerous, we could that, because we do it all the time, where we will strike a certain part of an order based on the age of a dog, the ability of that dog, or whatever it is. So I don't know. I just feel like to have the same evidentiary standard for both, or to have different for both, but be able to still put the same level of, it's a word on a piece of paper versus what's actually happening in real life as far as what we're doing after the fact. I don't know. I mean, I'm not against either way. I just I don't know how to.
That,
I understand your point of view, Tom, and I think it's a valid observation. But using the example you gave, that basically if we had two different sets of recommendations for a potentially dangerous and a dangerous animal, and we're looking at a dangerous cases presented to the commission as a dangerous case, but after our deliberations, we decide that the evidence presented did not meet a dangerous designation and those subsequent recommendations, that it gets downgraded because they met that evidentiary boundary.
Right.
So we have now potentially, in that example, Tom, we potentially have a dangerous animal that's going to have less recommendations on it, all because we didn't have an eyewitness.
Right.
Okay.
I get
And
that.
and Mike, and that's what I want to protect against. That if we're going to have these, if we got, I think it's
I see what you're saying.
it's a
If we're
backstop.
okay.
I think it's a backstop, so that if we get clipped technically that we have to downgrade somebody from a dangerous
Okay.
to a PDO, we at least have the same protective measures in place so that we don't suffer any more human or animal injury.
All right, I'm with you now.
So that's why that I would proffer for you to consider keeping the recommendations the same and giving the public the potential of
Right.
differentiating these based on the evidence that's presented.
You swung me back, Doc. You swung me back.
I'm not sure.
I know, I understand, but
yeah.
no, putting it that way, that makes more sense to me. I mean, I understand. Like I've always struggled with the fact that a potentially dangerous and a dangerous animal potentially are dealing with the same kind of aftermath. I always
had that problem.
Seemed odd to
Me
me
too.
that we're talking about the difference in the cost. I always felt like that should be addressed somewhere, but no, the way you just explained that though, it makes a lot more sense actually. So I'm glad I'm glad I had the thought and brought it out anyway.
I just
I'm glad you brought it up, Tom.
I just want to give a little bit more background based on what you just said. So it's important to note that the public safety laws and striking the right balance, right? I mean, that's really what we're trying to do with the public safety laws has been something that our county has struggled with for many years. And what brought this first to fruition was that back in 2017, there was an incident. And back at this time, what we had in the laws was potentially dangerous, and retain of custody. So and when these laws were in existence, for an animal to be declared potentially dangerous, the definitions were much more stringent in the sense that it could we couldn't do anything more than an order if one animal had killed another domesticated animal. So we had a small dog that was killed by a small leash dog that was with its family that was killed by an off leash large dog, and its family had tried to protect it. And all our section could do based on the code at that time was a potentially dangerous order for the attacking dog. And those owners in the community were in an uproar that we were allowing that dog, which the community felt like was vicious, to return to the community, even with those stipulations in place. So there was what was named then Lilo's Law went into place. And at this time, the same thought process as what Tom pretty well just discussed, which was basically the only difference between potentially dangerous and dangerous now is a little bit of a fee, right? I mean, you can do all of the same things and then the current level of evidence is the same right now. And it doesn't matter. So Lilo's Law removed dangerous as removed potentially dangerous as an option. And the law became only that our options were dangerous or vicious. That also created the dangerous animal registry. It did a lot of those things to really tighten the public safety laws to err more on the side of safety. That led to a higher number of dangerous orders, a higher number of vicious orders. And some of those animals, like the chickens that I mentioned earlier, are things that really called into question then, what is this too strict? Have we kind of erred too far and reacted a little bit too much and made things too stringent? So then in 2018, the laws were amended again to add back in potentially dangerous, and they were written in a manner that gave our section the ability to look at the totality of the situation, and also required that we look at the totality of the situation and all of the facts and information that is available, and added in what was then called determinative factors to ensure that it was clear that when there was a clear reasoning behind what had happened, that our agency was not required to move forward with an order, and that we had the option to decline to move forward with an order in cases where we didn't feel like that was appropriate. And that's pretty well the legislation that we're dealing with now. But I felt like, especially because we have some members on the commission that may not have been here a while, a little bit of history on how we got to where we are, and that we're really just trying to fine tune it to help ensure that as a community, we're doing our best to strike a balance between public safety and animal welfare.
Thank you, Robin.
You all had enough discussion on this potentially dangerous one. Do you want to have a motion on that, or do you want to continue to discuss more and then we'll on to dangerous?
I'll make a
one?
motion that we change the wording on the potentially dangerous, instead of being clear and convincing, to a preponderance of the evidence, and that we keep the evidentiary requirement for dangerous and vicious as they have presented to us. Keep them the same.
And I will second that.
Hang on, I'm writing before I take a vote. Hang tight with me. I apologize. Okay, all in favor? Okay, got it. Okay. Okay, so the next section that's different, we're moving on to within vicious. It is making changes to require both for current situations and for previous situations that we cannot do a vicious order unless we have eyewitness testimony to the events or authenticated digital evidence. For background purposes, and again, I just want to discuss, I like to do comparisons with criminal because that's something that's more familiar to everybody. In criminal law, where you're required to do clear and convincing or beyond a reasonable doubt, they do not, to come to those conclusions, restrict what types of evidence is required to do that. So for example, if I murdered someone, not saying that I did, but say I murdered someone, the person that I murdered obviously wouldn't be an eyewitness because they wouldn't be here to testify to that. And if I murdered them in their house, it's probably unlikely that you're going to have any video evidence of me having done that. And yet the police department is able to put away people who have murdered each other on a regular basis for the rest of their lives without that type of evidence available. They do it based on the totality of the information, using circumstantial evidence and other types of evidence to create that level of proof required.
Completely agree with Robin on this. In my mind, And I'll just let you guys know, I mean, I'm good with changing the standard of vicious dog to, beyond a reasonable doubt. I think it's a serious enough designation for the animal to raise the standard that high. But I also think having done that, you eliminates, in my mind, the need to dictate, the evidentiary components. And, like I said, Robin's correct. We don't do that in any other case. You leave that to the trier of fact and you assume that they can make that decision well. And if that's good enough for humans, I think it's good enough for animals. And I think elevating the standard eliminates the need to dictate the evidence.
And that's what section 1 and 2 do, Jennifer. Am I understanding that correctly? The what 1 and 2 do is that they're telling you what you have to make it beyond a reasonable doubt in this statute. Is that what that's doing?
Basically,
Okay.
It says you can't get to beyond a reasonable doubt unless you have an eyewitness or authenticated digital evidence. And I mean, a lot of the times, yes, it helps to have an eyewitness. I think that might have helped. Had the eyewitness been able to testify, that might have eliminated some of the issues in the Lucy and Odin case. However, there's other ways to get to beyond a reasonable doubt. Circumstantial evidence can be just so overwhelming that a jury or us as a commission or anybody else just reasonably couldn't come to any other conclusion. So I just don't think you need to, or actually, I don't think there's any reason to ever dictate the evidence. You can either prove your case or you can't. And once that standard has gone to the highest one, which is beyond a reasonable doubt, you ought to be able to put whatever evidence out there that, you feel gets you there.
And so you're suggesting we delete those two, Jennifer? Would that be your recommendation?
Yes,
Section
my
1 and 2.
recommendation would, I'm not speaking to the, in number 2 previously.
You're just
has been
speaking to
added
number
as well.
1.
And, right. I'm just speaking at this point about number 1, deleting the evidence, or the requirement that it be eyewitness or digital evidence, and the requirement in number 2 that it be eyewitness or digital evidence. It's the same thing in either one, and I don't think it's necessary in either place. What I'm not commenting on is the change to the previously. Third word of number 2 has been added, and I'm not commenting on that at all.
Okay, so do you want to make that a motion, Jennifer?
Well, no one else has discussed it, so I don't want to make a motion till I've heard everyone else's opinions.
Okay.
Go ahead, Ed.
Let me ask this. Let's suppose in that case, we didn't have any eyewitnesses and no digital evidence, but yet the dead animal was examined by a veterinarian who said that there were sufficient puncture marks on the body, and that was done within 24 hours. Let's say, like would that be enough evidence? See, so I'm kind of confused. If we remove that and we get that, how do we know that it was from dogs and not foxes or something like that? That's the only thing that's in my mind.
Well, you don't know, and that's what maybe prevents you from getting to beyond a reasonable doubt.
Exactly.
And that's the whole point of elevating the standard, right? You don't know. If there's another plausible explanation, then you haven't gotten to beyond a reasonable doubt. But if there's no other plausible explanation for what happened based on the evidence presented, okay, then you can move forward. But that's the whole reason for elevating the standard.
And that's what I'm saying. So if we had that in that case, we still wouldn't be able. I mean, that's all. If that was all we had, let's say, was a veterinarian's examination of the carcass, and we had that, we couldn't get beyond a reasonable doubt. with that
Right,
because it,
but you may have been able to get clear and convincing or preponderance of the evidence, which you all recommended bringing it down to a dangerous order. I think it's also important to note that animal care and control does not have the resources to send out every animal to a veterinarian, and without having ECU come over on every single case and do saliva testing, et cetera, getting to beyond a reasonable doubt is going to be difficult. And I can tell you that ECU and other things are pretty backed up. So getting those things for an animal case is going to be highly unlikely. And that is one thing that is important to remember, that in criminal cases, when we're prosecuting, we may have more resources that we can dedicate than we would when we're dealing with an animal public safety case.
I mean, you don't know if the owner would have done, highly unlikely, but the owner could have done that. And I'm just thinking forward, that's all. And
In
in a way,
response to Robin's comment, though, I guess, and I'm not unsympathetic to, what animal care and control goes through. I mean, and I agree, they don't have the resources to do it. But I have a hard time saying, well, this dog should die because the resources aren't available to prove its case one way or the other. I mean, the animal doesn't ever get to speak for itself. So I don't know. I'm comfortable with raising that standard.
Yeah, I have no problem at all with raising the standard. I do agree that, that the evidence should just be, we should strike those two sections. I mean, my thoughts go to like a small child. That are you going to put a small child, maybe a 4-year-old child that was out riding their bike that got attacked, viciously? Is that going to be you're going to have this child have to testify because maybe they were the only one that saw the situation? They're out front playing, this thing happens. You don't have video evidence, so that would be the only way that animal is dealt with. Where I think that's a tough situation for a child, or maybe someone who's mentally handicapped or something like that couldn't, it happened to them. It would be hard to get evidentiary, evidence from them. So I agree with Jennifer's first statement.
I agree as well. And that was my question. I believe that although well-meaning, I think it constrains.
Okay, so I guess now maybe I'll go make can we talk real quick about the addition of the previously? Because I'm not understanding that.
Real quick, guys, do you want to vote on number 1 first, so that way we don't get it confused, because the previously is going to throw us off, I feel like. Should we just vote on number 1?
Then I will make all right, then I'll make a motion that we keep the determination of beyond a reasonable doubt for vicious orders.
That one's already in. We're at the evidence. Beyond a reasonable doubt, you already voted for.
Oh, okay. Then I make a motion that we delete the evidentiary requirements in section 1 and 2 for that we have to have a witness or digital evidence.
I second that.
Yeah.
Second. And now seconded by Corporal Wall. Okay, all in favor? Unanimous. Okay, thank you. Okay, now it sounds like we want to discuss what the previously does in there. Essentially, and Office of Law can feel free to chime in here if I'm misreading this. My understanding of this is to catch our animals that either you all have seen or you haven't seen because the owners didn't appeal an administrative order. It already have an administrative order, so I think the previously is just to be clear that has been determined is from something before as opposed to something new. Has been determined to be either potentially dangerous or dangerous, and then it is involved in another public safety incident. So I think that previous is just for the purpose of making it clearer that that would have been from a prior incident.
Yeah, that's how I read it. I just assumed that it was making sure that we weren't, it wasn't based on what the case at the time on hand was. It was from a previous case.
Yeah, and Office of Law did weigh in and say, yes, that's correct. They did so in the chat.
Okay, but even, just so I'm clear, even if the animal had previously been designated as dangerous, we're still, whatever the current allegation is, that's still being viewed entirely separate and still being held to a beyond a reasonable doubt standard, correct?
Oh, that's a fair question, and I don't know the answer to that.
I think that's a very good point, Jennifer. I was under the impression from my previous serving on the commission that these PDOs, dangerous and vicious, were on a sliding scale. So that if you got determined to be a potentially dangerous dog, you had a second event, you could be bumped up, depending on the circumstances, to a dangerous or a vicious animal. I thought that was already in the system, and that's how we handled those cases. If we had a potentially dangerous dog return to us for another incident, and if that's the case, then I think, just as Jennifer pointed out, we really don't need them to tell us what evidence we need. They just have to present whatever they've got to reach, for us to determine whether it's dangerous or vicious. I guess the question only becomes that, since this is a sliding scale forward, that if the animal comes to us and they're dangerous, that if they present evidence beyond a reasonable doubt, that we just determine that animal to be vicious, and we take the consequences from there. So I think we're at the same, that's what I think the previously means, is that we're just seeing an animal we've already adjudicated coming back for a second instance for whatever the cause.
But I think Jennifer's question is that previous, and Jennifer, feel free to correct me if I'm wrong, that previous case and this current second or later incident, are both of those being held to the beyond a reasonable doubt standard? Are we reopening the old case, or is it just the beyond a reasonable doubt standard for this second newest case? Am I saying that right, Jennifer?
Yeah, I guess.
I guess it's my understanding that if they've been previously determined, so we have a dog coming to us that attacked a dog and killed it, and that dog's already been determined to be potentially dangerous or dangerous. All we need to know is what our previous adjudication was, because all we're going to look at is this animal now has got a second incident. So by default, whatever the next escalating level of determination is, whether it's dangerous or vicious, is what this animal is going to get labeled with. And then based on what we previously decided, they have to prove that this animal did this to become vicious to beyond a reasonable doubt. That's how I'm understanding this. We're not going back in what we've previously adjudicated, but we have that prior history that we know that we can't look at this individual case and determine that this dog can be just a PDO again. The animal's had a second bite that's come before the commission. We have to escalate its classification. That's how I'm understanding this.
I don't think you would have to. I think
That's my,
the laws. I don't think I don't see a shall here.
Okay.
That's what I typically look for when it's a mandated that we have to do it.
Okay.
I think
So
that more
then-
goes to my question. I was more concerned that that they were putting the previously in because it somehow I mean, I understand that if we now have a dog coming back again, and I'm not disparaging dogs, it just seems to be more often dogs when,
Right.
But if we have a dog come back now for a second time, that yes, this could be demonstrating a pattern, but I want to make sure that we're still reviewing the current issue on its own merits and not using the prior ruling. Because I mean, we can't do that in the normal court, in regular cases. I mean, you can't use prior behavior as proof of behavior in a certain
But this isn't
circumstance
prior.
now, unless I guess
This
that's
isn't.
what I just, every case should stand on its own merits. So just because the dog I mean, it might have had a previous bite, maybe, and that was legitimate. And no, I'm not saying we go that any of that goes back in date, because there's nothing in this statute to suggest it's retroactive. But whatever is coming before us now,
Should be beyond a reasonable
is decided
doubt
on
based
its
on your prior vote.
right, is decided on its own merit and not.
Correct. But I think when we're deciding this, I don't think we're talking about, and certainly I'll defer to you because you're the attorney here. We're not talking about previous behavior. We're talking about, if you'll excuse the vernacular, previous conviction. Just like with the case this morning, the guy had a previous affidavit. If an animal is coming to me before and it's already been determined to be a PDO, I kind of don't care about what happened in that case, because all I really have to know is that this dog has been convicted, for lack of a better word, as a potentially dangerous or dangerous dog. Now we have to take that under advisement as we look at the new case as it's being presented. And it was my understanding, likely mistaken, that if this was a PDO or dangerous dog, we would not be looking at this separate incident as we'd be looking at for a PDO for a dangerous. And if it was a dangerous dog, previously designated as a dangerous dog, we'd be looking this as a vicious order. Now, Robbins corrected me and said that's not necessarily the case because the word shall is not in the statute. So the question that I have is that, how do we handle these situations where we have, as Jennifer pointed out, we're looking at this new case all on its merits, all on its own merits, and whatever the evidentiary standard that they're going to have to prove is. So now I can potentially have a dog that's bitten another dog, killed a cat, and now has nipped at a human. Based on all those individual cases, that dog could be labeled 3 times as potentially dangerous. And he's still out in the community wreaking havoc.
But if you're able to prove that third case beyond a reasonable doubt, then you for the
You're right.
Right?
You're absolutely right.
But it is a lot of ifs and buts.
Yeah, it is. Absolutely. And I go, how are we serving? And this is why I think the escalation concept is important, because ultimately what we're tasked here with as commissioners is to support the police department and public safety. And how are we supporting public safety when we've got a dog that's bit another dog, killed a cat, and nipped at a human, with 3 potentially dangerous orders still in the community? How have we supported public safety?
Well,
Very, very globally speaking.
let me ask a question here. I've been listening. If we have an animal with a PDO or a dangerous order, they have conditions put upon it to not be able to repeat that action. So if that action from the PDO or the dangerous order has been repeated, isn't it because one of the restrictions that was placed upon it is not being adhered to? That would be the fault of the owner. I think inside that order, there's also penalties for that. In other words, you have to meet ABC before you can even get your dog back after an incident. And, okay, well, if you lift one of those, I think we're looking at the fact that the owner has violated the PDO or the dangerous order.
But we have no recourse. As a commission, we have no recourse against the human other than raising the licensing fees. We can't, if they violate an order, it's my understanding, we as a commission cannot do anything to the owner.
Well, we do
That
have
has, because once they break an order, that becomes a criminal complaint and that goes down law enforcement.
well,
That's my understanding.
we do have the new law of the
Reckless animal owner.
yes, the reckless animal owner, where if there's two incidences, I believe, Robin, you can correct me if I'm wrong. I think it's a 24-month period. If they have 2 or 3 incidences, I can't remember which.
I was gonna pull it up so that everybody has the opportunity to look at it. We, in the time since that law was passed, we haven't actually been, I don't think, able to use it on anyone because of the way that it is written.
I would suggest that be
threshold for getting
incorporated
here is tough.
into this. And
Yeah, but isn't that beyond the scope of what we as a commission can do?
well, we as a commission are not doing it. We're suggesting it.
Correct. Yeah.
I would suggest incorporating that or maybe having the council take a look at this and modify it if we're having incidents that are repetitive, but there might not be within the confines of this particular wording, maybe modifying it so that we have less repeats. So in other words, if it's an 18-month period and we got 24-month period on here, I can't see it really that well,
Do I
but
need to try and zoom in?
Can you scroll down to the penalties, Robin?
The penalties?
I think this is a really important part of our discussion because the crux of all of this, whether the dog is potentially dangerous, vicious, has had prior instances or not, is whether or not the owner is responsible enough to care for this animal safely.
correct.
And that's why we tried to create this law, but as I said, we haven't been able to use it. And just so that you all hopefully have a better understanding, the reason we haven't really been able to use it is because they have to be found guilty of violating the provisions within a certain period of time. And unfortunately, the system is not very fast. And so for citations, for violations to make it through the system, there have to be a lot of incidences. For us to even issue a citation, our team members either have to witness it or we have to have an affidavit, a sworn affidavit for someone who witnessed it. So we run into these, or what we found, we made this with great intent to be able to hold reckless owners responsible. But what we're finding is that getting to that multiple guilties for during a 24-month period is proving much more difficult than we anticipated. We primarily have this, not thankfully for public safety cases, but we're primarily running into this for frequent at-large cases where we have the animal impounded for being at large numerous times. And an animal impounded is not the same as being found guilty. So unless there is a citation that goes along with that, and we don't typically get these, a finder that finds an animal isn't typically then also doing an affidavit of complaint for an animal at large, and therefore our officer's not witnessing it. We don't have an affidavit of complaint. We can't issue an at large. We can't then get to court for that citation to get it upheld as guilty to then move on. So that is where we've been running into issues, is that the way this was written, while well intended, and I'm behind it. So you know, experience is a learning curve for us, is that it has not been effective because it does require that guilty.
Robin, just asking, how could it be more effective? Is there a way to suggest this be included and modified in a way to be more effective? Like maybe the 24-month period be reduced a little bit to be more effective or whatever? Because I think this particular law, I mean, I like it because there are a lot of reckless animals owners. And I think if we could tighten that up, you know, it would probably serve the public safety a lot better. You know, in this discussion, I think the two should go together. That this legislation that we're looking at right now, and we have this already on the books. I don't think that the council should look past this to get to this.
So in answer to your question, it's it actually shortening the time period would make it even more difficult.
Oh,
Eliminating it would be best.
Yeah, eliminating it would be helpful, or doing something similar to how we have, I kind of tried to go to a different part of the code so you can see it. One of the things that has been reasonably successful for this is that it used to be that the impoundment fee was the same, whether it was your first impoundment or your fifth impoundment. But what we were able to do was modify the impoundment so that on impoundments, it goes up. Something similar to that would do it, or including that maybe it got another order or something. Things that don't require a specific guilty finding, although I realize that we can't really get to potentially dangerous, or vicious without some type of guilty finding. It doesn't count as a guilty finding because it's not related to a citation, if I'm explaining that in a manner. But yes, Jennifer's suggestion of who cares how long it takes is also helpful. But I can tell you that, like, right now, for example, when we experienced this, I think in October, we were told that none of our animal cases would be getting to district court until January. That just to give you an idea of sometimes what the process can truly be like. You know, we do run into, there are other things on the docket that must be heard. And we have to wait for space and time for our cases to be heard. And before that, we have to be able to serve the citation, right, to the individual, which sometimes takes certified mail, an animal care and control officer going out, the sheriff's department going out. I mean, there's all these steps to try and get to a guilty verdict on a citation.
so
Hey, Robin, which agency brings the reckless owner charge?
Say this again?
Which agency would bring a reckless owner charge? Would that be
We
you, the
would.
police? Okay.
We would.
would it be feasible to, instead of waiting for a guilty verdict, base it upon the impoundments?
That would certainly be feasible.
You know, a certain amount of impoundments, during a certain amount of time. I think, you know, if that was looked at, that would probably help the cause a little bit. But I don't want to get too much off track. I know I've taken it off track. What we're looking at is in front of us, but I don't think the two should be separate. Because when you know, when we're talking about repeat offenses, it's not necessarily the animal that's doing the offending. It's the owner allowing the animal to do the offending. And I think we need to focus on that, because we're doing what we can by placing these restrictions on them through a PDO or a dangerous order. And, you know, yes, our officers go out and they say, okay, you got the secondary barrier, you got this, you got that. But then 2 months later, you know, we can't send one out there every day. We can't send an officer out there every week to make sure that everything is still in place like they did when it was observed. And then if it's lifted, then we get these repeat offenses, like is what we're discussing here. So I just wanted to mention, I think that I think that the two go hand in hand. The irresponsible pet owners or the reckless animal owner maybe needs to be modified so that we could get an actual hand on the ones that take the PDOs and the dangerous orders, and then just allow violations of that later on down the road.
Those are very good points, Ed. Thank you. And Robin, thank you for the education about the reckless owner. I was unaware of that. Here's a pivot in a different direction. Let me throw this out for that section 2. Why don't we consider be guilty of becoming a reckless owner in that section 2, so that if they're previously determined to be potentially dangerous or dangerous, they have a second incident as a public safety threat, that they're determined to be a reckless owner. We get that on the legislation, and just try to
I think we can add it as a comment in the minutes, because they're really looking for our feedback, but I don't
Okay.
think we have any, I mean, like, I don't think we can actually add to this at the stage it's in now. I mean,
Sure.
doing it this way, I mean, we're either agreeing or disagreeing with their proposed changes, and then we can give them additional feedback. And if that's one of the
Okay.
pieces of feedback, I think that's great. I would suggest, since I don't think any of us are really sure 100% the purpose of that previously, I would suggest that the commission take no position on it, on that particular change, and then include in the comments, we'd like, because we already know for that section 2 that we're striking the evidentiary requirement, or we think it should be deleted. I'm not sure I can take a position on that, the addition of that word previously, because I'm not clear on the intent and how it's in, they're expecting it to be used. And then we could put a comment in the minutes saying we should add in that, or tie it to the reckless pet owner statute, maybe.
Yeah, I think that's
But
I think that cleaned up my thought very nicely, Jennifer. Thank you for that, seeing through that concisely. Yeah.
So can I just weigh in on, for number 2, the way I read it, because it sounds like the question is that, are you only looking at the previous incident? And the way I read number 2, because it says previously determined to be potentially dangerous and engages in a second incident. So I'm reading it as you need both the previous incident as well as whatever is before you current, whatever the current case is, as well as the previous incident. So you're still looking at whatever the case is before you. You're not only looking at the previous incident. That's the way I read.
Well, then my question becomes, because it's in all caps, it's a change,
Addition,
right?
the previous.
Right, it's an addition.
Suggested addition.
It's an addition. So that means that number 2 used to say, or in its existing form says, has been determined to be potentially dangerous or dangerous. How is that different from has been previously determined to be potential? Do you understand what I mean, Robbie, you're laughing,
Yeah.
but I mean, to me,
Nope.
it's a distinction without a difference.
Now I understand the question you're asking now, and I don't know what the difference would be. I was addressing your first question as to whether or not you were only looking at the previous incident. I don't know what the difference would be with adding this previously to number 2. So if you want to put that in a comment to have that, if you need that more clearly defined or fleshed out.
I think the only thing that would make sense to me with the previously is that, like, if we're in the middle of a case and during that case we've determined, like, let's say this is the first incident or whatever, or even the second incident, whatever, but we've determined during this case that, okay, this has risen to the level of a potentially dangerous order, and we're still discussing whether it should go further than that. Is that the only reason why previously should be added, so that we're not considering it in that way? You understand what I'm saying? I don't even want to keep guessing. I'm with you. I kind of feel like we should just, ask why, without their knowing the intent. That's my guess at the intent is to just say, hey, the animal hasn't been determined at this juncture to have been potentially dangerous. You know what I mean? Like that's the only thing. So I agree with you, Jennifer. Just without knowing whoever put it in there's intent.
Or currently under potentially dangerous or dangerous orders.
We can certainly, I mean, if someone, maybe Jennifer wants to make a motion to say we don't want to comment on this unless we get clarification as to the intent. Or not we, because I don't have a vote. Just
Okay, I make a
Yeah.
motion that we not take a position on the addition of the word previously until we know the intent behind it.
I'll second
I
that.
second that. Yeah. Yeah, perfect.
But let me ask a question here. Currently, when I've seen the language, when a PDO or a dangerous order is imposed, doesn't it say in the last paragraph that this is for the life of the animal?
yes.
Okay, well then, I see number 2 as actually meaning is currently under a potentially or dangerous order, and then commits a violation of that while on that. That's what it means. I think that's my interpretation of it.
Well, I think Jennifer's motion is appropriate, that we just need to find out what the intent is. I mean, if you take previously out, it still makes sense. I agree with Jennifer. I don't know what the previously means.
So
Yeah.
I mean, I suspect, and I think I tried to say this earlier, but maybe not so eloquently, and I think Tom tried to say it too, is that it would have had to have had an order before and still have, as Ed pointed out, an order from before and been engaged in another incident. Maybe the clarification is previously is so that no one thinks that by deeming something potentially dangerous or dangerous, I don't know, during investigation, or I don't like it. So say we were investigating it, but hadn't issued the order yet, maybe that's what the clarification is for. And then we came up with potentially dangerous or dangerous, but it hadn't yet been through the appeals process, but they'd complied and taken the animal home, maybe, and it was involved in something else. I don't know. I'm just kind of devil's advocating here. I think the plan.
That's my whole point. There were 3
Yeah.
maybes in that, and since we
Yeah.
don't know, somebody's got to explain it.
Yeah.
Yeah. Well, we have Jennifer's motion on the table, guys.
All right.
We need to vote. It's been
Vote.
seconded.
All in favor? That's unanimous. Okay, thank you. All right, the next thing that is a suggested change, and maybe Aisha can comment here, is changing E for what's currently listed as determinative factors to be mitigating circumstances. I don't know what the difference is. To me, they both have the same, it doesn't change the outcome of how this section is used, but maybe there is some legal that I don't understand.
Hold on real quick, guys. Do we need to go back to number 2 for that last line that we took out of number 1?
Oh, no, we took it out with taking out number 1.
Okay, so that's connected?
Yeah, we did
Yes.
number 1 and number 2. We removed that whole portion at the same time, and then we went back to deal with
Okay.
just previous.
Previous. Okay, I just want to make sure. Thank you.
Thank you. Jennifer, I don't know if there's a legal.
I think it's just bringing it more in line with other portions of the code.
Okay.
What's described in that section really is mitigating circumstances. Meaning we've agreed it happened, the attack happened, but there could be a good reason behind it. And we use mitigating circumstances in a variety of things. There's mitigating circumstances in accident cases and in other criminal cases. So I really think it just brings it more in line with other portions of the code. And I'm in favor of making that change unless somebody has a reason not to. Then I would make a motion that, that we accept the change to mitigating circumstances.
I second.
Yeah. Mhm.
Okay, all in favor?
That's what they are.
Okay, look, that one was fast. Great job, guys. Okay, all right, and then this next section, which is 12.4.403, is essentially taking the modified, what they're suggested were for potentially dangerous and dangerous up to clear and convincing, and for vicious, taking that up to reasonable doubt, just again, kind of reaffirming what the level of evidence or burden of proof levels are required for those particular types. That's me putting it in layman's terms. Jennifer, I don't know if you want to say it a different way.
And that's
Well,
exactly what it is. But since we already agreed we were going to keep the preponderance of evidence for a PDO, this would need to be adjusted accordingly to match what we've already agreed we'd do,
agreed.
if that makes sense.
Is that
Yes.
a motion?
That works. I second that. Yeah, because it just summarizes what we said in the second section, that consequences are determined because the appeal should be the same burden of proof. That determination of potentially dangerous should be by preponderance of the evidence. A dangerous will be clear and convincing, and vicious will be meet the criteria of beyond a reasonable doubt.
Yep. Agreed.
Yeah.
Am I considering that a Brienza motion or a Hemmer motion?
Could be a Brienza motion. She had the idea. I'm good with that. I'll second it.
Okay. All in favor? Okay. Rolling right along here. This is a new section. This is a reconsideration section. And my understanding of this is that after a year, but before, let me just make sure I've seen a different version of this as well. So I'm struggling with how to summarize. Essentially, my understanding of this is that it is adding the ability for an owner to appeal the conditions in an order after a period of time, but before another period of time. And then it can go before the commission again.
As I read this, I fundamentally don't have a problem with it. And where I'm going with this is that we're not changing the designation of the animals. If it's potentially dangerous, it's potentially dangerous. This gets back to Tom's points earlier, where how we should have different conditions for PDO, dangerous, and vicious. This reconsideration I like because these are lifelong determinations for these animals. That means that if we have a 2-year-old dog that fits somebody that we determine is a potentially dangerous, now that 2-year-old's a 14-year-old and can't walk anymore.
14. It wouldn't be 14 the way this is written, I don't think. Jennifer, correct me if I'm wrong.
No sooner.
Yeah.
I don't see an end date on it. Right. You
There's
can't,
not.
you can't
You can
ask
only do
for a
it once.
change within the first year, and you can't ask for more than one change within any subsequent year, but I don't see any end restriction unless we're looking at something different.
Hang on, the other version of it that I saw, hang on. That. it
Yeah,
said,
this is,
petition to reconsider may not be filed until 1 year and no more than 2 years from the date of issuance.
oh,
No,
Um,
It's not in what we're looking at.
yeah,
I-
it's not in what you're looking at.
no,
So what's
I-
correct? What do
because
we have?
Aisha,
Doc-
do you know from Office of Law which version is for sure the version we should be looking at?
The one that I have is the one you have, Robin, that says the no more than 2 years from the date of the issuance of the order.
All
That's
right,
the
let
one
me
that I
pull
have.
that one up so that the commission can see that.
Yeah, I mean, if that's the case, I agree with you, Dr. Hom. I mean, there's definitely mitigating circumstances potentially after 2 years that
Yeah,
could
yeah.
change the outcome for that person. So I mean, like I said, an animal maybe loses a leg or generally gets old and can't do certain things, and maybe
Yeah.
the owner wants to move to a home that doesn't have a 6-foot fence and the animal can't jump a fence anymore. I mean, there's plenty of things we can look at. So
Yeah.
I mean, we just had a case recently where,
or
Go ahead.
whatever.
Yeah, I fundamentally like it. It gives us some more flexibility to help these animals as they get older, reintegrate back into the community if they've been behaving and the owners have been complying. And I think that addresses Tom's concern that we don't have any changes in the requirements for a PDO and the dangerous. This gives us some flexibility after a year to revisit an issue should the owner want to do that. I mean, I like it.
I do too. Yeah. Yeah. I like it. The one here. I don't like the one with the 2-year cutoff date.
Yeah. I like the timing in this one too. I mean, so they can every year come before the commission and ask for a modification of their conditions. And I don't think that's unreasonable for any of us.
Okay, so it sounds like my understanding and Aisha's understanding is the same, that the version that you all have, that you all were sent and that I was originally sent, this is a more updated version. Oh, you've been trying to tell them. Is different. So if you want to take a minute to read that, I also went ahead and added it to the drive real quick. Under the legislation, if it's easier for you to pull it up on your computer rather than on the shared screen, I understand that. I can try to zoom and do other things, but I'm not Phil. There we go.
That's very good. Thank you, Robin.
You're welcome.
Yeah, I like this. I like this concept. And I would proffer to the commission that we change the timing in one to basically what was in.
Well,
I
don't mean to interrupt, but what are we looking at? Are we looking at this, what we have in front of us, or are we looking at what Robin is showing us? Because
it's my understanding, Ed, that what Robin's showing us is the most current version of the reconsideration section.
Is it?
And
because I'm just wondering if what we're looking at here with the 12 months and nothing else has already been redone.
If this has been redone, then I don't like it because I'd like to have the public have the ability with PDO and the dangerous dogs, as the animal advances in age and is still following the conditions, be able to get the conditions modified as the pet ages. I don't think that's unreasonable.
I agree. I meant that the draft that we're looking at is the latest version. Could that be possible?
I'm guessing the one on the screen is the latest version because the one that we were given, it was written in paragraph form. And the one on the screen is written in the more typical section form so that it could be easily cited and broken down, you know, D1, D3, whereas you can't do that when it's in paragraph form. So I'm guessing the one on the screen is the more current version, and that's what we should be addressing.
Well, I hate to say this, but are there any other differences in what is on the screen and what we have been looking at in this draft?
Robin, the one that we got was from November 13th, the original one that I'm looking at, but it's not dated on there. You know, when yours was this new one has no date on it either, does it?
No, my understanding is that this is the most up-to-date one. I think this one was sent to me Thursday night of last week by Kelly Kinney from Office of Law. Or Thursday afternoon.
I
Not to note
suggest,
that I want to create any longer problems, but is this the only thing that's different, or have we already voted on stuff that is different?
This is the only thing that's different.
Okay.
I'm happy to scroll, but my understanding is that's the only thing that's different. It's got the domesticated definition there. It's got clear and convincing for both of those. Beyond a reasonable doubt, the specific types of evidence required. This one doesn't show the change from determinative factors to mitigating circumstances, but I think it's intended to be there. And then that we've just looked at. So I think that this is the only thing that's different.
Okay.
I'd like to make a motion that we recommend on item 1 under the reconsideration that we strike the no more than 2 years and leave it as open-ended on a time factor.
I'll second that.
Okay, all in favor? Wait, I switch you all. Let's see. I'll put sharing back up, sorry. That's unanimous, right?
Yes.
Sorry, it just won't let me see everyone and share at the same time.
Then if I'm reading that right, Robin, the only thing that I would proffer to the commission that we take a stand on is that I still like that wording that we don't change the no, it's already in there, never mind.
Yeah, it's in there. It's just in a different
I'm
place.
Good. Yep, yeah, it is. We're good. Okay.
Okay, all done with the reconsideration one, or is there another portion?
I have one question because there's one other thing that's different. In the paragraph form we were given, it says they're not allowed to ask for a reconsideration more than one time in a 12-month period, and that's absent in here. And the only reason I'm questioning that, because I get it, circumstances can change at any time. I just also know that, you know, like you said, animal control, everybody else is kind of short-staffed. I didn't know you know, how many petitions you wanted to interchange just in case you had a particularly litigious person upset about their ruling and wanted to continuously filing. Is there any merit to having a limit to how many you can do in a year?
I think that's reasonable, Jennifer, and I agree with you. I think having it open-ended that it doesn't sunset or end, I think is good, but I think we probably do need to put some kind of moderator on there, because we will have those members of the public who will file for reconsideration every month till the dog dies. And I mean,
Yep.
I can easily see that. I would proffer to say maybe, you know, that you can't petition for reconsideration more than once every 18 months.
I think
That would be my.
I think that no more than one time in a 12-month period, like they already had it, should be reinducted into this one.
Not more than one time in a 12-month period is what the other version says.
Yeah, they already
Right.
somebody We put that in the draft. And I think that was reasonable.
Yeah, I agree with that. I'm good with that.
Is that your motion, Dr. Hemmer?
Yes, yes. Make a
Second.
motion that we put a time limit on there to once every 12 months, like Ed suggested.
And your second then is Ed?
Yes, ma'am.
All right, all in favor? Oh, wait, hang on, let me stop sharing to do this so that I can see you all. All in favor? Unanimous. Anything else that you all want to discuss on the reconsideration?
No, ma'am.
Okay, so then we move on to our last section. We're almost done, guys, in the home stretch. The last section is modifying the licensing fees for dangerous and potentially dangerous animals. And what this proposes is having the fee be the heightened fee for the first year, and then after that reverting to whatever the fee is standard for that animal.
I don't have a problem with that. I would just see that fee, instead of going for 1 year, maybe going 3 years and then reverting back.
I don't understand the point of reducing it.
Save
It's-
money for the animal owner. So you
Well,
all are
obviously,
talking about
but
it correctly.
You gotta realize that if we impose a PDO or a dangerous odor, they're 9 times out of 10 they're going to be putting up a fence. They're going to be making secondary barriers, and purchasing muzzles and all that kind of stuff. I don't know. So this may be kind of related to that.
Are those fees directly tied to your budget?
No,
Evan?
no, and they used to be higher. It used to be, I think when I started, I'm just gonna go back to one of the other legislative changes, but I want to say they used to be 250 and
Yeah.
250 and 150, I think is what I have in my head, but I'm looking.
Yeah, I think that's what I recall, Robin, from the last time I was on the commission. They were much higher.
Yeah, so these are reduced from what they used to be. And animal care and control does have to go out and do, pre-inspections before an animal is released. And when we have the staff, we try to do annual inspections. And of course, we do go do inspections if there's complaints of any violations.
Yeah, and that's what I was concerned with your budget. I mean, if those fees are directly tied to that, and I know you have staffing issues trying to get that people out there to figure out these things are being upheld, and administrative issues and stuff around the office there. So I didn't want you losing out on that deal.
I mean, these fees wouldn't cover the costs of our staffing and.
Well,
and
I get that, but I'm just saying, like, one, for that person's, for a year's worth of administrative fees for that process of you having to schedule appointments and get people out there, the fuel, all those real costs. I mean, I want to make sure that it's but if it doesn't come directly to you anyway, then I have no direct problem with them reducing it.
How about offering that it be a decreasing scale, like the 125 the first year, then half of that the second year, and then the third year back to the normal?
I mean, I kind of like that too, because I do like the fact that people have to think a little bit more about it. If all of a sudden it reverts right back to the normal fee, then all of a sudden they have their normal dog, and maybe they get a little more lax on the stuff that they're supposed to be doing.
Yeah, I think if they still have to make the investment, it will help them to maintain what they need to do.
And that's why I'm recommending that's why I would suggest we keep it the same for the first 3 years.
Yeah, I mean, I like that too. I mean, I like maybe, same for the first 3 years, as long as there's no incidents, then you reduce it. And if there's an
Yeah.
incident those 3 years, then it would continue to stay,
How about a
Absolutely.
compromise on that with the 125 the first year, then half the next 2 years?
What I don't know is half of the 125 going to be less than the regular license fee, Robin?
No, so regular licenses, keep in mind that we require spaying and neutering of all animals that get an order. So regular licenses could be as low as $0 if you're a senior
Okay.
citizen and your pet is spayed or neutered. Or $2 if you're not a senior citizen and your pet is spayed or neutered for 1 year license, or $5 for
Okay, so substantially. Okay. Yeah, I can work with that too. Yeah, that's reasonable.
Do I hear a motion?
I think that,
To ask a question, I guess, when I look at the totality of these changes, I mean, with the exception of the PD, right, and a PDO, does that licensing fee, it says for a dangerous animal, so that doesn't, that does not apply to a dog that just has a PDO, is that correct?
So this legislation has both, hang on, I'll just share screen again. It has both for dangerous and potentially dangerous. Dangerous is the top.
Oh, I see.
Dangerous is the 125 first year, and then it's suggesting revert to standard after, and then below that it has potentially dangerous 100 for the first year and then revert. Sorry about that.
I'm not sure that I care a whole lot about this, but I guess my question was, I mean, we're increasing the standards, we're making it harder to get for a dog, for an animal to be designated that way. So to me, that in effect eliminates some of these higher thing, I don't think as many animals, maybe, I don't know, that's wishful thinking. I don't know, it just seems, I guess, if it is what it is, I'm not sure why we're backing off the fees. And like I said, not that I care, I'm good with the do it after 1 year or gradually reduce it
Yeah.
after 3. I was just curious why you would change it at all.
I think the,
It's for the benefit of the animal owner.
Yeah.
is my understanding.
Yeah, they got to get them spayed. They have to do all the compliance with the orders. Just another fee, just increase their cost of pet ownership. But there has to be some punitive measure here going forward, which is why I think having it for 3 years, or as Jacqueline suggested, we half it every year after that or something. I think we have to have some financial punitive measure in place, but I don't know that we need to have the punitive measure intact for the rest of the animal's life. That's my comment.
Well, and the owner is going to be going through a lot more measures than the average owner. And I think that by reducing the license fee a little bit after the first year, it's commending them for making the effort rather than just dumping the dog at the shelter and giving up on it.
Oh, that's a good point. Okay.
And
That's a good point.
maybe I'll change my recommendation on the fee structure itself from 125 to 75 for the next couple of years. And then on the one that's 100, 100 and then 50.
Is that a motion?
Yeah, make that as a motion. I'm good with that.
Yeah.
Then I'll second it.
And so that is, just to be clear, Jackie, I'm changing it to year 1 for DO is 125. Year 2 is 75.
Mm-hmm.
Year 3 is 75. Year 4 is reverts.
Mm-hmm.
And then similar fee structure for the PDO, 100, 50, 50 reverts.
Yes.
Okay, all in favor? Unanimous. That concludes everything that we have on the agenda for today. Our next hearing
January 8th.
is January 8th, because the first Monday of January is the new year. So we won't be having a hearing then. So it would be January 8th. I do want to take the opportunity to wish everybody a happy holiday season, since I won't see you all until after.
You
these.
too.
Thank you, Robin. You guys, yeah, everybody
Thanks,
have a
Robin. You too.
happy holiday
Yep,
season.
same to everybody.
Thank you.
Okay.
Anything else anyone wants to bring up before we conclude? Okay, is there?
No, I
good.
move,
Go ahead.
no, I
Thank
move we adjourn.
I second.
Meeting adjourned then.
All in favor?
Happy holidays.
All in favor?
Unanimous.
Yeah, guys, see you.
All
Happy
take-
holidays,
Bye,
guys.
everybody.
Take care.
Have a good one.
You too.